We're going to hear evidence now from Louise Casey, who's the Independent Commissioner for Victims and Witnesses, and also from Victims Support. Could I welcome our witnesses to the committee and ask if you'd like to introduce yourselves to the committee, and if you'd like to make a brief statement to the committee, you're invited to do so.
Hi, my name's Sally Jimson. I'm Head of Public Policy at Victim Support. I think you know about Victim Support, but I'd just like to tell you just a little bit about us. We're an independent charity for victims and witnesses of crime. We were set up 35 years ago. We cover England and Wales. We're volunteer-based with 6,500 volunteers and about 1,600 staff up and down the country. We contact about over 1 million victims a year, and we run the witness service, which is that we have volunteers in every criminal court in the country, from the Old Bailey to Newcastle. Since April 2010, we have a specialist homicide service, so we support almost all the families, bereaved families of homicide. We are also the biggest employer of independent domestic violence advocates in the country, employing about 92 of them. And at the moment, we're being funded by the Victims Commissioner for victim service advocates. There are three things that we would like to say. First of all, that we welcome the introduction of the powers to enable money to be deducted from prisoners' wages to go towards victim support services. So we're very, very supportive of that. But overall, we think this bill represents a missed opportunity to make the criminal justice system work better for victims. We're particularly concerned about three things: suspended sentences, not necessarily having a community requirement attached, which means that offenders in serious cases could simply walk free. And we know that many victims, that victims want the offender to be punished, and there would effectively be, in this case, no punishment. And even in some cases when that was breached, the only sanction would be a fine. The second thing is that we think that the bill could have done more for victims to make provision for the Victims' Compensation Fund. At the moment, victims can get, so we're happy that there is a duty for the compensation fund, but worried that victims won't necessarily get the money, that there's no means to enforce that better than at the moment. The government hasn't done this, and we think it's a missed opportunity, because victims tell us that they get money in dribs and comes through from offenders in dribs and drabs, and we would like there to be a compensation fund so that the money is funded up front. And it is then it would be that fund that would then get the money off the offenders. And we're also concerned that the bill waters down or doesn't have a duty to explain sentences to victims, only a duty to explain it in more ordinary language to offenders. And when we asked victims very recently what the one thing that they would want to make the criminal justice system better, 48% said that they wanted more clarity in sentencing.
Chairman, I'm very grateful for the opportunity to appear before the Scrutiny Committee today. I want to take a slightly different approach to this, which is I think the first thing that I say as the Victims Commissioner is that we understand completely and are very supportive of the need for the criminal justice system to do a better job in the rehabilitation of criminals and offenders, and think that that is a right and proper thing to happen. I feel all too often I certainly am under pressure to be in this position as a Victims Commissioner that says don't spend money on rehabilitating criminals, you should do this and not that. You get into this world, if you're pro-offender it means you're anti-victim, if you're pro-victim it means that therefore you are anti-offender, and that's not where the Victims Commissioner, this one, is. And I also feel very strongly the evidence in terms of our Green Paper response is victims also do not want offenders to continue to go on committing further offences and creating more and more victims. So I think it is right and proper that this bill is before the House, and right and proper that it enjoys this scrutiny. It's not just the financial cost of what criminals do to us in our society, it is also the sort of human, personal, emotional and social cost, which I think I highlighted pretty squarely in the report I delivered to ministers last week on the needs of families bereaved through murder and manslaughter. So I think that we need to be in a place where I do believe it is right that we are rehabilitating criminals and spending time and energy on that. That said, of course, I'm also very grateful, I think, on behalf of victim support and myself, that actually I think it is a huge step forward that this committee has asked to see victims' voices, as it were, as part of what it is you are doing as this bill proceeds. It is really important, I think, that given we know that over 2/3 of the public believe the criminal justice system respects the rights of perpetrators, offenders, criminals, more than less than 1/3 than it believes the rights of victims are respected, that at every single point when issues about crime and justice and offenders are discussed, I think it is right and proper, and I have the privilege of being the sort of statutory voice of therefore what happens with victims, which is why I have taken myself down a route of suggesting we need legislation for victims, a victims' law. So I'm very pleased that we're here today, and pleased as well that as you look at even elements of this, which my friend and colleague has mentioned a number, that we look at them through the eyes of the victim, because actually the eyes of the victim are also where the wider public are. So there is a kind of connection between those two. I do want to say, though, that we were really pleased with the government's response to the Green Paper consultation. There were a couple of elements, particularly the not guilty early credit, where victims felt, and I felt, it stretched the sort of integrity of the principle of that sentence, a stretch too far, and that we were really pleased. In fact, I felt some level of relief that was not proceeded with, and I think showed real willingness by the government to sort of look at it through the eyes of victims, and we were very grateful for that. My last point, and I'll keep it brief because I'm sure you want to get it, is that overall I think it's important that all of the different elements, whether it's suspended sentences, compensation orders, curfews or whatever, that one looks at them through the principles that underlie that criminal justice system. And what the public, and therefore what victims, want is that when somebody breaks a law, there is a consequence to that that is punitive, which is why I would support Victim Support's position. For example, it is the right thing, possibly, that we give more discretion to judges to actually suspend sentences for longer. That might be a right and proper place to be. I think that is probably correct. The quid pro quo of that, though, is that that can't just be seen as 2 years to keep your nose clean and there's no consequence to it, i.e. it's like a bind-over. You're just told to get on with your business for a couple of years and there isn't any punishment. The same way, I am really pleased with the government's position on criminals essentially paying back to victims and to society more broadly, which I think is a very big political principle which I and victims would sign up to. The quid pro quo of that is that once it's gone through a bill and is in reality in the street and is in the courts, that victims have to know that they're not going to be strung along and given £1 a week and then it drops off from a compensation order. So it's not that the principle is wrong, it's just that the delivery of it is a really tall order. And I think it's not necessarily therefore about a bill that goes through Parliament, it's more about the huge pressure, as one sort of perhaps rightly considers whether you downward trend custodial sentences. What you have to do is therefore make non-custodial sentences much more punitive, much more upfront and in the face of the public, so that they can have greater confidence in them. And I think that nobody in this House should underestimate just what a tall order that is. So I suppose it's kind of weird. I'm jumping possibly to once this is happening and saying compo orders don't always get paid back. How are they going to be? I mean, I think I was somebody who was very involved with the changes to community payback and trying to get people to don an orange jacket just with the word community payback on the back. And the last administration, that was a really tall order to drive through. So I think the delivery of some of these things are going to be where the test of the bill stands or fails.
Kate Green, Damien Hines, Dave Watts, Helen Goodman, Elfyn Thwyd, Robert Buckland, Alex Cunningham, Andy Slaughter. Kate.
Thank you very much. And just immediately to follow the point made by Louise Casey and the increasing emphasis that the bill will place on strong community penalties, do you consider the probation service will be adequately resourced and equipped to supervise those offenders who will now be serving sentences in the community and therefore more in the face of their victims?
My view, and it's not the first time I will have said it, is that I have had for a number of years, ever since I did a review into the public's view of the criminal justice system, which is the probation service would need to significantly shift in its culture. It's not necessarily an issue about money and resources, that might be the case, but it's certainly an issue in terms of culture that I have felt that they are resistant to things like asking people to go and put orange jackets on, a whole sense of moving people out of charity shops where they're invisible and it's a pretty easy ride, into cleaning the streets, which is what you want. If actually you're stopping short of locking somebody up on a short-term prison sentence, you need something that's of the equivalent weight of that. And I think, Mrs. Green, we have really struggled to get the probation service to, I think the modern word is step change, and I still feel that to this day.
And I mean, I think that's right. I think that victims really want to know that if it's going to be a community sentence, that actually works, and that there's some sort of evidence that this is going to prevent reoffending, because victims want punishment, or tell us that they want punishment, but they also don't want that person to do it again. So there really does have to be investment in rehabilitation, as the Commissioner said, in order to make sure that it doesn't happen, that for victims, that it doesn't happen again.
Damien Hines.
Following on from Kate's questioning, where they are custodial sentences, what evidence, what polling evidence or whatever do you have from victims about what they think prisoners should be doing in prison, whether in terms of work and rehab and education and so on, and the type of work? And also within work, we've talked a lot about making deductions to help to fund victim support charities and also creating a savings account. What do you think is an appropriate proportion of prisoner earnings to be deducted to aid victim support?
Louise Casey.
When we did the department asked me to consult with victims during the course of the Green Paper, and we carried out quite a thorough consultation. And I have to say, the wholesale support for the word work and making prisons places of work just was relentless. I mean, it's absolutely, they are absolutely clear that they think prisons should be places of work. In terms of, obviously, I am of the view, because I'm the Victims Commissioner, that actually I would say a very significant proportion of that money should go towards victim services. I am hoping that this will be one of the ways of actually getting more money into services for victims, which historically have enjoyed quite a tiny amount of money from the criminal justice bill. I think it's less than 1 to 2% of the entire spend in the criminal justice system goes towards victims. So I am ever hopeful that both the victim surcharge and prisoners' earnings will be a very significant part of how we can get better services for victims. And I think that's the quid pro quo again, which is it's right that we spend rehabilitation money on on offenders, as long as we're also rehabilitating victims. And I can assure you, as my report last week showed, that there are plenty of parents and grandparents around the country that have to spend their own resources on counselling, therapy and support for children that have been bereaved through murder and manslaughter and other homicides. So I feel we need to just level playing field, and this is one of the ways in which we can level it up.
Damien Hines.
And what do victims think about the concept of work in prison being optional or voluntary?
I don't think I'd have to work very hard to say, I'm sure you know what I'm going to say to that, and I don't need to spend money on a poll to tell you they would suggest to you it should be hard, people should be made to work, and that they think that some of the earnings should go towards services for victims.
Dave
No,
Watts.
and I would agree. I mean, that's
Sorry, Sally Gimson.
no. I would agree that victims do want prisoners to actually work, and for prison to work in a sense.
Dave Watts.
From prisoners' associations about the difficulties of the present bail system and about the court system. From the victim's point of view, one of the things I hear, and I'd just be interested to hear your own views on this, is that many people complain about repeat offences being committed by people on bail, and many people complain that once people are bailed, they do fail to turn up for the next court sessions. What's the views of victims about the proposal? Because it seems that you're going to have more of that.
I think we are very concerned. We are very concerned about the proposals to restrict the use of pre-trial custody. We, particularly where there's a risk that the defendant might not come back, but also might intimidate the victims or the witnesses. And we don't see within the bill enough safeguards put in for victims and witnesses. It's simply talked about in terms of if the defendant might need protection, and only for victims and witnesses in terms of domestic violence. So yes, we are worried that there might be more defendants on bail who would not, who might intimidate victims and witnesses, and who might not come to trial.
And if there were further cuts in youth offending teams and probation teams, would that mean that victims would be less happy, with even more unhappy about the proposals?
Yes, I think that's absolutely right. They need to have reassurance that if people are out there, that they are being monitored, and that they will come back to court, and that they will face the consequences. Only 10% of people who report a crime told us that their case actually went to court. For those people that go to court, it's absolutely essential that it happens, and that defendant is tried.
Robert Buckland.
I just want to look at the proposals to alter the duty on the court to explain the effective sentence. I don't know whether you'd agree with this proposition, but over the last few years, because of the amount of changes, judges have really had to undertake some sort of steeplechase and try and explain sentences which have become more and more enshrined in jargon. Do you not welcome the re-emphasis in the proposed new clause to try and explain things in ordinary language, which will not only assist those in court, but could also assist the translation of that message to victims who very often will not be there to hear the sentence?
Absolutely. Absolutely. No, we think it's very important that should be explained in ordinary language, but it doesn't mention the victims it doesn't actually mention victims in the bill. So we would like to see that they were mentioned as well as defendants. And very often victims, as you say, are not in court, and they may either not understand if they're told at all, and they may not be told. They may not understand. We talked to a woman who is a victim of assault. She'd been told that it would be 9 months, but the person only served 4. She didn't really understand why that happened, and felt that all that experience that she'd gone through in court had been for something, for nothing, and that in fact she'd sort of been re-victimised and hadn't got justice. So I think there does need, and then they're victims who never go to court, only read about what happens in the local paper. So we really do feel that there needs to be clarity in sentencing within the court, but also the victim needs to be told what happened and needs to understand that when a sentence is explained, that's exactly what is going to happen.
Louise Casey.
If I may, this has been something since 2008 that I have been pushing for, and I am really pleased that it is in the bill, in that I think it is a step forward, definitely, that judges will have to explain sentences. I entirely agree with Sally that explaining a sentence to a defender, who now is an offender actually by this stage because he's been done for it, he has his lawyer sat next to him taking that down and he can explain it to him later. Our problem is there's nobody on our side that can then explain it to the victim. So I think greater care, it would be good if greater care could be given to the victim's aspect in all of it. Again, I think though that this is a very welcome move in relation to cases that are very serious, such as murder, manslaughter and rape, and possibly child sex offences and violence offences. It would make sense to me, and it certainly makes sense to a lot of other people. The evidence shows that some of that is delivered in writing. And at the moment, very high court judges that are very senior actually hand out their written sentencing remarks. And I can assure members of all sides that actually that is a really positive move for victims because a lot of them pore over those for years to come. So written would be good. May I, Chairman, just say a very quick word about bail, which is, I just wanted to say there is a real principle here which is at stake about bail. We believe, and in the consultation, which is, I think the principle should be why detention, or what the law currently stands is, will you go and do it again whilst you're on bail? Are you going to interfere with victims in the way that Sally talked about? Are you already a non-appearer? And actually, have you got a real address that we can actually bail you to? They seem like the right sorts of principles that you would look at a bail case on, as opposed to changing the rules slightly and saying, well, actually, this is going to be about other type, what your sentence might be were you to be found guilty. I don't see a case for changing the principle so significantly, though we are enormously grateful, as ministers and colleagues know, to have at least the sort of safeguard in there on domestic violence, but we would prefer it not to proceed at all.
We've got 9 minutes left and 5 speakers have caught my eye. Helen Goodman, Elizabeth Truss, Elfyn Clwyd, Alex Cunningham, Andy Slaughter. Helen Goodman.
On suspended sentences, Louise Casey, you said that it could appear as no punishment, a kind of bind-over. Are you advocating, in essence, suspended sentences plus?
Well,
Louise Casey.
Yes.
Have you thought any more?
Sorry, I don't mean to be flippant. It's I'm just so conscious of your time. At the moment, when you suspend the sentence, there's normally a community requirement attached to that. Obviously, I'd like to see people. It's a very serious thing to hand out a suspended sentence. You're not in fine territory. You're up the tariff. I think cleaning the streets for a few hours would be are the sorts of things that should be considered.
So when people breach suspended sentence orders, I think both of you expressed some doubt about simply imposing a fine. Have you got any information for us on who would benefit from the proposals that the government is making here?
Who would benefit?
Yeah.
Presumably the
what
offender.
What kind of offender?
We don't know.
What
I would say is the sort of scenario that possibly could work is you suspend a sentence, you do a compensation order, and if we're so serious about compensation that if you then breach that compensation order, are you then saying you essentially, your suspended sentence days are over and you're looking at custody? I mean, that's the type of thing which would work in terms of being punitive enough to reassure victims and the wider public about compensation orders and about suspended sentences. So I can see ways that you could make this work. I just think saying to judges, you can have 2 years, which may be absolutely right, but not putting any punishment element into it, and it's for others to decide what that punishment element looks like, just looks like a consequence-free couple of years. And yet it's further up the tariff in punishment than fining someone. So there's a oddness to it around the principle of what you're using suspended sentences for when we know they are such serious disposals.
Elizabeth Truss.
Thank you. I completely agree with your comment earlier that there's an issue about the culture and organisation of resources in the prison and probation service rather than pure cost. And we do have one of the most expensive justice systems in the world per head. Now, I support the vision of the non-system as it was created, but my question is, how can that actually be put into practice when the bill is implemented to create a much more seamless prison and probation operation rather than the very different cultures we have at the moment?
Louise Casey.
I mean, this is my view, so this wasn't subject of the consultation as part of the Green Paper, but I think that there is a crossroads, really, I think, in the world of probation, which is, are we saying to people in probation, you're there to concentrate on rehabilitation? It's your job to think about how you rehabilitate. When it comes to doing seriously tough community punishment, i.e., you know, that bridge being covered with people in orange jackets cleaning it on a regular basis, is that the right organisation to be having that responsibility as well? Now, there are ways with contracting out, reform of the probation service that may be possible. I'm simply saying, Mrs. Truss, that so far, my experience now over quite a long period of time is that the probation service hasn't reached that far, and it would take a brave and determined and seriously determined reform of the probation service to get them there. So is it time that we think about whether it's the right organisation between the punishment aspects of community orders?
Elfyn Squid.
Can I just go back to what Ms Jimson was saying about explaining sentences?
Yeah.
The duty in the bill is to use ordinary language, which may be a tall order with some senior judges. But anyway, I put to a senior judge recently in the Justice Committee that would it not be a good thing if the Crown Court Associate or the Magistrate's Clerk sitting in court were to take down a note of the salient points of the sentence and then communicate that directly to the victim. I think it's straightforward, it's simple. I was told they're too busy. Well, I'm sorry, it's a long-standing problem. It seems to be a simple answer. What do you think?
No, I think I absolutely think that is the simple answer. It's a good idea. And if the justice system is not there for victims, who are sort of a representative in a sense of the general public, who is it there for? And I think that the court should have a duty to do that, yes.
Okay. Andy Slaughter.
Can I just turn to parts 1 and 2 of the bill briefly, which are also about witnesses, victims in their own way, about the victims of tortfeasors or about people who are trying to get compensation. And for example, we have CICA cases removed from scope of legal aid, and if victims are suing under the new CFA system, the possibility that 25% of their damages will go to pay their lawyers' fees. Have you looked at those, and do you have any concerns about those changes?
I haven't.
Sally Gibson.
I haven't. I can get you we haven't looked into that. I can get you a note on that.
I think we'd be interested, particularly in the issue around CIC, Criminal Injuries Compensation Authority, which, as we understand it, will no longer be eligible for legal assistance in relation to legal aid.
I mean, I think
Louise Casey.
Mr. Slaughter, what I would say as a general principle about criminals' injury compensation scheme is that victims regularly feed back. In fact, in the review that we published last week, I think almost 50% of victims' families, because these are murder and manslaughter cases, said that the complexity and the administration and the headbanging of Kicker as it stands just adds insult to injury, and that, you know, it sticks in my gullet slightly that we're having to pay cutbacks to lawyers through private lawyers to process some of these claims because actually the system is so complicated. Yeah. So, I mean, I think I have again put on record that if nothing else, I think the time is right to look at Kicker as an administrative burden on victims, frankly, which is the only way I can describe it, and certainly victim support colleagues throughout the country, when I do visits there, which they very kindly allow me to do, often a lot of their work is about doing the bloody... not allowed to swear at scrutiny committees, and I'm on tape, but I can't tell you how frustrating it is for victims and their families, the bureaucracy around Kicker, the kind of complications around something that should be so straightforward, and we end up giving 25% to these people that text you nowadays to tell you, have you got a claim? It's not right, and it needs to be stopped.
And I think I rather misunderstood the question. Yeah. I mean, I'm absolutely with Louise about this. Kicker, it can take over 2 years to get, more than 2 years for thousands of victims to get the money off it. It really, and they have to fill in loads and loads of forms, and they get repeatedly asked for evidence that goes over a long time.
Will it be more difficult?
It's not at the moment the way it
will it be more difficult for victims if they cannot get legal assistance or assistance generally to help them?
Well, it should just be easier to get. It should just be easier to get it, and it should be some of that gathering of evidence, which is where the problem problem is should happen
Order.
locally.
Order. Sorry to interrupt one of our witnesses, but can I thank you both for giving your time this morning and giving evidence to the committee. Thank you very much indeed.